the matters were listed.
Okay, okay.
Much okay.
I have prayed for a regular bail application manner for Friday night. Another same court case has been fixed on 1st of August now.
1st of August.
Okay.
Back to Benchmark item number 56 of today's list. Okay. Here also the petitioner filed this bail application after filing of charge sheet lodging, and lodging was called for the case records and fix the matter today. But in between lodges, the NBWA issued against the present petitioner. So may I pray that this matter will be taken up as last item before rising lodging. Otherwise, if he is arrested, that matter will become.
It is otherwise last item.
Therefore, before rising lodging, therefore I am saying.
If it reaches, we will take it up.
Before rising lodging may take up. Because only I will pray for the interim order that execution of warrant of arrest may be issued. Only that much. As last item before rising lodging.
Okay.
Public.
Please, Your Lordship. Lordship, I beg to action for listing of the bail matter. It's quite urgent. Reason being,
When have you filed?
we filed it on last Friday.
It has not yet been listed.
It may be listed tomorrow.
Okay. Okay. Motion. Okay.
Deeply open.
Your Lordship, I beg to mention for listing of a bail application tomorrow of bail filing number 718.
When have you filed?
7, Your Lordship.
Yesterday. Day after tomorrow.
I need to mention for adjournment item number 23, madam. I have taken consent from the petitioner.
I am appearing for the petitioner.
Item number 20.
23, madam.
2-3, my lord. Admission item.
Private restaurant and
Heard Mr. What is your name?
AK Azad.
A.K. Azad, learned counsel for respondent number 2, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. A. Tiwari, learned counsel for the petitioner, who does not have any objection to this said prayer. Hence, the prayer is allowed.
Second week of August.
Let this matter be listed in the second week of August on a date to be fixed by registry.
Give you a pleasure.
If possible, madam.
Let the registry do its work.
May please look at my lord. I have filed a bail petition today itself, my lord. My lord, who is already granted bail, my lord.
No, that may not be ground for early listing. It will be listed in its due course. If it does not get listed within 2 days, you can make mention. You have to wait for that period.
Another item 48, my lord. Perhaps my lord CD is not received, my lord. So my lord, let them in the next week.
Item number 48,
40,
47 and 48.
47 and 40.
CD is not there. Otherwise CD is there. 47 and 48. Heard Mr.
I is in for 48.
Is for 40.
Heard Mr. K. Parashar, learned additional public prosecutor, who prays for some more time for production of the case diary. The prayer is allowed. Let this matter be listed 18th of August.
Yeah, please. I beg to mention item number 24. It's a criminal petition. May the taken method may be taken after 2 weeks.
Why?
Senior concepts of personal difficulties. 24.
You are appearing for?
Yeah.
What is your name?
And Ghosh.
Heard Mr. N. Ghosh, submitting on behalf of Mr. A. Lal, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. Considering the submissions of the petition, learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
I would like to mention for listing of a criminal petition.
Senior court.
That is here in, I'm praying for listing one criminal read petition, your Lord.
Senior
That's
court.
supposed to be listed.
Should I like to mention item 54 of supplement for upgrade lordship, 57 days in the custody lordship. Mandatory
No
period
upgradation, you have to wait.
is about complete lordship. 57 days today.
3 days are there. We'll see whether it reaches or not. Otherwise, we'll fix it tomorrow or day after tomorrow.
Please, the Lordship. Lordship, I beg to mention item number 39. It is not available.
Item number 39. Heard Mr. K.K. Parashar, learned counsel, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed on 22nd August. The interim order shall continue till next day.
Please, your lordship. Item number 7. It might be taken tomorrow, my lord. We have some difficulties today. It's in the motion column. 7.
On request of learned counsel for the petitioner, let this matter be listed tomorrow, that is on 31st.
Okay.
Wait, Lordship. I beg to mention item number 40, Lordship. This method, we are going to file one additional affidavit today, Lordship, during the course of the day. So matter may be taken up tomorrow, Lord. It is not.
Item number?
Item number 40. 40. On the last of the Lordship, I request to file one additional affidavit.
Heard Mr. R. Sharma, learned counsel for the petitioner, who prays for an adjournment on the ground that the petitioner is going to file an additional affidavit today. So, considering the submissions made by learned counsel, let this matter be listed tomorrow.
Also, interim may be one.
Interim order shall continue till next day.
Daily list motion be item number 1.
Maybe Lordship, 4:3 regular well, Lordship. Basically, the matter is head, Lordship. Today, 32 days, the FIR is at page 11, Lordship.
Where is the rejection order?
Lordship, first appearance.
Heard Mr. What is your name?
This,
J. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, call for the case diary. When?
13.
13th of August.
the 32 days, Lordship. Otherwise. no-
We are helpless. You have to wait for the,
I need to
Devolve this.
May please, but the regular bail application, charge sheet case, section 6 of the POXO is there, Lordship.
heard Mr. Ain Hassan, learned counsel for the petitioner, also heard Mr. K.K. Das, learned additional public prosecutor. Issue notice to the respondent number 2 and 3. Respondent number 2. Who is 3?
3 is not there.
Okay, sorry,
petitioner.
sorry. Respondent number 2.
Mother of the-
In pursuant to the prevailing notification of the registry in this regard, the petitioner shall take steps for taking shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 22nd of August. What is your ground?
Check there, the notices 47, 48.
Let also the scan copy of the case diary of
The scan copy of the trial court record.
case diary as well as scan copy of the trial court records be called for.
I need to
May I please, Lordship? I am not in the case, I am on behalf of K.K. Ahmed. It's regular bail application, my lord. Like, so, better my lord, kindly issue notice the information.
What is your name?
K.K.
Heard Mr. A.K. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das. It is pending investigation.
Fine.
Call for the case diary. and issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on shorter date, 18th August.
Item 4. May it please your lordship.
My lord, the petitioner was arrested on 17/11/2024, and today is, my lord, 225 days is behind the bar. And my lord, within time, my lord, the charge sheet was submitted. And my lord, the learned special, my lord, Judge Poxo Kamrup, my lord, and charge also framed, my lord.
What is your ground?
Government, since long days, my lord, he's behind the bar. And my lord,
How many witnesses have been examined?
only one.
Victim has been examined.
Yes.
Heard Mr. N. Uddin, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the scanned copy of the trial court records as well as trial court records. Stop. Issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 22nd of August.
5.
Lordship Poxo is their lordship. FIR lordship page.
What is your name?
It's
Heard Miss J. Akhtar, learned counsel for the petitioner. Also heard Mr. K.K. Das. Agor orders, same order repeat. Date 22 August. No short date. It is a charge sheeted case. Call for the case diary. Case diary 18th August.
Item 6.
I am late when Mr. A. Is on legal. Kindly taken over person.
What is the matter?
Matter versus the petitioner. The certificate case, lordship, Poxo case.
So notice will go to. Heard Mr. What is your name?
I'm R. Islam.
Heard Mr. R. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Das. Issue Agor order. Call for the scan copy of the trial court records. 22nd.
Lordship, the victim and the informant has already examined, lordship. Other witnesses are turning up. Petitioner behind the bar since 2nd of January 2025, lordship.
18th.
1 year.
18th.
And that section 47 and 48 notice.
18th of August.
Lordship, that also be called for, lordship. 47 and 48 notice.
Also called for the scan copy of the case diary.
Item 8. May it please your lordship. This is a regular bill application lordship. The matter pertains to the recovery of 39 numbers of cattle lordship. Your lordship has already granted interim protection to the petitioner, owner of the cattle as well as lordship, the owner of the vehicle lordship. And so for this petitioner lordship, the petitioner had a petition number 1 is a driver of the vehicle lordships and rest of the lordships, the helper of the and handyman of the vehicle lordships. Your lordship has
Where is the rejection order?
your lordship has granted bail to the cattle owner.
No, but why have you not approached the trial court first? You have not approached the trial court. You have directly come to this court. Case diary would be required.
There's a 20 days in custody lordship.
You should have,
I'm sorry for that lordship, but
we are also sorry.
lordship, 20 days in custody lordship. And more lordship, this is not
no,
stolen cattle.
no.
It's just mentioned that lordship one.
You have to approach the nearer court first. Thereafter, you may heard Mr. T. Srutia learned.
That was my earlier lordship. On our Guwahati High Court, but
You want to withdraw or should I?
I am sorry for that lordship. But
You want to withdraw or should I?
lordship, 20 days in custody lordship.
You have an option,
So that I have given also.
8th of August. You have to think about these things before filing bail application directly to High Court. It will not that on your filing you will get bail. When you have jumped one forum, though there is no illegality, but there is also no illegality if we insist on perusal of the case diary.
So that's what that may be given also. 20 days there in custody also. Application shorter also.
7th of August.
7th of.
Call for the case diary, T. Sutya. 7th of August.
I'm obliged.
I didn't mind. Made close. Let's say this is a POCSO case. I have been in custody for 312 days. My ground is counts of arrest and I am not implicated in the 164 statement.
Charge sheeted case.
That's it.
Why your prayer was rejected by the trial court?
This is the last order. The page number.
What is the stage of trial?
Trial court said that I am implicated, but one in the 164 I am not implicated.
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the scanned copy of trial court records as well as scanned copy of the case diary. List this matter on 22nd.
I think.
Those make an
also there.
Issue notice to respondent number 2 in pursuant to the notification of the registry. In this regard, the petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 18th of August. Ma'am.
Lordship, Lordship. It's a charge-sheeted case, Your Lordship. So here this case, Your Lordship, after filing of the charge sheet and taking cognizance of problem, someone was issued and accordingly I did appear, Your Lordship. But what happened subsequently, Your Lordship, after the COVID-19, Your Lordship?
You
That is-
defaulted.
Yes, defaulted, got transferred.
Thereafter,
Thereafter, Your Lordship, on, Your Lordship, a case kindly be.
no, you tell me the facts. Thereafter NBW was issued.
Yes, first of all, BW was issued, Your Lordship.
Then you were arrested.
BW was issued.
Now you are behind the bars.
Yes, Your Lordship, yes.
You have to tell me the facts, not
Yes, Your Lordship. Now I am behind the bar, Your Lordship.
now. What is your ground?
I come that Your
Why the trial court rejected the prayer for bail after you were arrested?
Lordship, we have not approached before the trial court.
No, you were approached before the trial court first. Because you were arrested on after issuance of non-bailable warrant. Heard Mr. A. Diwan, learned counsel for the petitioner. After you were arrested in pursuant to the non-bailable warrant issued by the trial court, you did not pray for bail before the said court. Go and pray there. Learned, this application under section 483 of BNSS has been filed by the petitioner, namely Mosaid Ali, who has been detained behind the bars in connection with since when? Since 28/6/2025 in connection with special POCSO case number 62/22 under section 365/376D of Indian Penal Code, read with section 4 of the POCSO Act 2012. Learned counsel for the petitioner has submitted that the petitioner had appeared before the trial court in pursuant to the summons issued by the trial court, and he was earlier granted bail. However, he defaulted in regularly appearing before the trial court, and accordingly, trial court issued non-bailable warrant of arrest. Stop. He submits that in execution of the non-bailable warrant of arrest issued against him, he was again arrested on 28/6/2025. Stop. On a specific query posed by this court, the learned counsel for the petitioner submits that after getting arrested in execution of the non-bailable warrant of arrest issued by the trial court, he had not approached before the trial court. Stop. And has directly approached this court. Stop. Though there is no legal bar in approaching this court, however, this court is of considered opinion that when the trial court is competent enough to consider and even grant bail to the petitioner, if it thinks fit to do so, the petitioner should have approached the trial court first. Accordingly, this bail application is rejected with an observation that petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
Filing the regular bail application in lawsuit that may kindly be considered in law. That observation.
Why are you apprehending that it will not be considered?
Because of the fact you lost it. Because first of all.
No such observation.
Lost it because of, first of all.
You give me a single case where after filing of the bail, it has not been considered by the trial court without considering. You tell me about this. See.
11. It's a commercial quantity manner, the NDPS case manner. It is in bar since 100 days manner.
What is your ground?
The investigating agency manner could not recover any article or substance.
It is pending investigation. Investigation is going on.
Yes.
Heard Mr. Ainuddin, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. Let this case be listed on 20 August.
12.
Lordship, the petitioner behind the bar since last 19 days, your lordship. All the student house were seized by the police, your lordship. And his name is not mentioned in the FIR.
Now, since last 19 days, where is the rejection order of the trial court?
See page number 17, your lordship.
Page number? We are giving a short date for case file. Heard Miss, what is her name? H.G. Daisy, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. Give a short date. 12th of August. We don't know what is there in the case diary against you.
13.
Maybe the lordship. Lordship, this is a 43 application. Lordship, charge sheet, seated case, lordship. Allegations in the case under POCSO, lordship.
What is your ground?
So, lordship, inadvertently, the respondent here is not made a party,
Respondent?
but the informant lordship. So lordship, we under 2 weeks of time to file an application.
To amend your application. Heard, Mr. What is your name?
S.A. Riaz on behalf of J.U. Ahmed Lordship.
S.A. Riaz submitting on behalf of Mr. J.U. Ahmed, who prays for allowing the petitioner to file an amended cause title in this bail application as the guardian of the victims slash guardian of the victim has not been made party in this case, which is required in such cases. The prayer is allowed. The petitioner may file amended cause title before the next date fixed. Let this case be listed again after 2 weeks on a date to be fixed by registry.
Clear, please.
Item 49 from supplementary list.
This is the lordship. My lord, for APC application and offences registered under 21B of the Narcotics Act, my lord.
21,
21B, my lord.
item number Kiman. How much narcotic?
102 grams of, my lord, powdery substance was recovered from.
Heroin,
Yes, my lord.
pending investigation.
Investigation. 39 days on.
Case diary would be required. Heard, Mr. M.A. Chaudhary, learned counsel for the petitioner, also heard Mr. K.K. Das. Call for the case diary.
On 19.
Let this matter be listed on 19th of
My lord, we are kindly, my lord. It will be, my lord, for more than
19th.
50 days, my lord.
more than 100 grams of heroin.
It falls within 20 within the definition of 21B, my lord, the intermediate quantity, my lord. 250
How
grams,
many days you are behind the bar?
39 days, my lord. That will be more than 50 days, my lord. That is the MP.
Thir- 13. 13.
14. So can you kindly pass over the matter for timely manner? Youngest council.
So
Item 15. Item number 15.
none has appeared for the
My lord, notice was issued to the respondent privately.
heard Mr. S.C. Bishwas, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Issue notice to respondent number 2.
Issued, my lord.
It was not issued. Today is the first date. Issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard and call for the. It is pending investigation. Call for the case diary. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 20. Yes. 20.
Item 16.
None has appeared for the petitioner on call. List this matter in the next week. List this matter on a date to be fixed by registry.
Item 17.
I have the lordship. Lordship, this is an attendance with bail application, lordship. The FIR is page 13, lordship. Lordship, may I
Yes.
Lordship, with reference to the subject cited above, I have the honor to report you that on
21B.
Yes, Lordship.
It is
Lordship, but I am not involved in this case because Lordship, I am the wife of the accused number 2, Lordship. Here the police have got information that 2 persons are selling the drugs in the area of Howley. Lordship, one is both the person were arrested, Lordship. My name is not there in the FIR, Lordship. Only I have been charging by the police because I am the wife of the accused number 2, Lordship. And
your husband has been arrested.
Yes, Lordship. Yes, both the accused person were arrested and later on granted bail by the court, Lordship. And if I read the FIR, Lordship, I am not here involved in this case. Police got information only for 2 persons.
one is male and one is female person, Lordship. And both
What was seized?
Lordship, 12 gram of heroin, Lordship, suspected heroin, Lordship. Information what I received for only 2 persons and both were arrested, Lordship. And I am serving by the police because I am the wife of the accused number 2, Lordship. And moreover, the police has not written my name as the accused, Lordship. At page 14, Lordship, name and address of the accused person. One is Shahida Begum and one is Alam Sikdar. Alam Sikdar is my husband, Lordship.
And what is your name?
My name is Halima Khatun. Halima Begum, Lordship. Lordship,
Why you are apprehending?
because the police has in the last part of page number 14, Lordship, only one line is there that the Alam Sikdar is also involved with his wife in the business of trafficking and selling of illicit narcotics.
So your involvement is there. Case diary would be necessary.
Lordship, first, mother of the 2 child, Lordship. I annexed the birth certificate. One
But
child,
accusation against you is there.
Lordship. 2 person, Lordship. And both them were arrested, Lordship.
What it means, Alam Sikdar is involved with his wife in the said business.
Maybe they, but why then police never not make me accused, Lordship, in the accused name and address of the accused person? Because Lordship, only some individual person has said my name to the police, Lordship. Only for that.
Section 29 is also there, Lordship.
Lordship, I am the mother of the 2 person, Lordship, 2 child, Lordship. Kindly see the page 23, Lordship. Birth certificate I have annexed, Lordship. So I have the 4 years. My child is 4 years, and without the petitioner, she cannot stay at the house, Lordship. Lordship, I may be protection. Then, Lordship,
Short
I-
date, not before that.
Before that, Lordship, then 8.
6.
I am humbly prayed to.
No, no. This is NDPS case and your name, you have been accused. Heard, Mr. What is your name? R. Islam Learned Counsel for the petitioner. Also heard Mr. K.K. Das, Learned Additional Public Prosecutor. Considering the nature of accusation leveled in the FIR, perusal of the case diary would be necessary. Hence call for the case diary. List this matter on 6th of August.
Item 18. May I please your lordship? 438 application, your lordship, FIR page 11. It is, my lord, case related to, my lord, recovery of beef meat, my lord. And the gist of the FIR is that, my lord, in 4 shops, my lord, police recovered certain amount of beef meat, my lord, and the petitioner has been made one of the accused, my lord.
Who are you?
I am the first one, my lord, Sarafat Ali.
Why are you apprehending?
As
In
per the-
your shop also beef was recovered.
Is that 11.785 kg was recovered, my lord. My lord, in this case, kindly see, my lord, at 9, the FIR, one Saiful Islam, my lord, from his shop, my lord, 36 kgs has been recovered, my lord. And the case has been fixed, my lord. He approached this honorable court, my lord. And your lordship is pleased to, my lord, fix the date on 18th August, my lord. And he has been granted, my lord, interim protection, my lord.
Okay.
The other accused, my lord. I'm placing the order.
Heard Mr. D. Sharma, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, K.K. Das, Learned Additional Public Prosecutor. This application under section 482 of BNSS has been filed by the petitioner Sharafat Ali, alias Sarafat Ali, who is apprehending his arrest in connection with Nagaon PS case number 520/2025 under section 196 within bracket 1 within bracket small b of BNS read with section 13 within bracket 1 of Assam Cattle Preservation Act. The gist of accusation from bail application number Yarpa Likhibo, from bail application number AB 1734 2025 para 3 उठाई দিব। Learned, this is the same case.
Same case, my lord, from four different shops, my lord, same case, case number is
Learned counsel for the petitioner submits that the petitioner is a owner of, you are owner of,
not the owner, my lord, falsely indicated, my lord, not the owner, actual owner.
petitioner is not the owner of the shop from where the beef meat was recovered. However, police is searching for him. He further submits that one of the co-accused, namely Saiful Islam, who had approached this court earlier by filing an anticipatory bail, that is AB case number 1734/2025, has been granted interim bail and case diary has been called for fixing 18th of August. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation and he may be granted interim protection in this case. On the other hand, learned additional public prosecutor raised for calling of the case diary and also objected to grant of any interim protection at this stage. So, considering the fact that the suspected beef meat has already been recovered and one of the co-accused has been granted interim protection, stop. Further, the petitioner is willing and ready to cooperate in the investigation. Hence, this court is inclined to grant interim protection to the petitioner. Stop. Call for the case diary. Release this matter on 18th of August. However, in the meanwhile, quote para 13 from the said bail application. That you appear before IO within 7 days. You are granted interim bail of 30,000 with 105 penalty. List accordingly.
I'm sorry, my lord, I was in the next court, item number 16 got missed. Can it be taken up at 2, my lord? If it is possible.
No. We'll call it.
Item 19.
You wait, not at 2 now. Okay.
Much please.
20. My lord, this is an anticipatory bail application, lordship. My lord, your lordship may kindly turn to the FIR lordship at page 11, lordship. Page 11 is the FIR lordship which was lost by the child protection officer, lordship. May I read it, lordship? In inviting a reference to the subject cited above, I am to inform you that on 23/6/2025, the DCPO Hailakandi received a complaint from CHL.
Who are you?
My lord, we are the adopted lordship parent. Lordship, here the case was registered under section 93, 143(4) and 80 of the lordship Juvenile Justice Act. Section 93 and 143(4) that are not applicable to us, lordship, because 93 is regarding lordship. 93 is regarding exposure of a child under 12 years of age by parent. So we are not the parent. Next lordship, 143(4) lordship, that is trafficking of a child. But as per statement of the FIR lordship, we are the adopted couple, lordship.
adopted or you adopted the,
Oh, we have adopted lordship, the child lordship. Although there are
no,
some,
not as per the procedure prescribed.
not as per, that's section 80. But section 80 is also not applicable because lordship, your lordship may kindly see section 80, what it says lordship. Section 80 of the Juvenile Justice Act.
Juvenile Justice Act.
Section 80. Yes, lordship.
Yes, read.
Section 80 of the Juvenile Justice Act, that punitive measures for adoption without following prescribed procedures. If any person or organization offers or gives or receives any orphan, abandoned or surrendered child for the purpose of adoption without following the provisions or procedures as provided in this act, such person or organization shall be punishable with imprisonment of either description for a term which may extend to 3 years or with fine or 1 lakh rupees. So here, lordship, the for effect of this section, lordship, the child shall be orphaned, abandoned or surrendered. But lordship, as per definition,
What is the definition of surrendered child?
yes, lordship, that as per definition of first lordship 2(1), abandoned child. Who is
No.
abandoned?
He is not abandoned.
Yes, lord. He is not abandoned, orphan or surrendered.
What is surrendered?
Yes, lord. Surrendered lordship, section 260, lord. Surrendered child means a child who is relinquished by the parent or guardian to the committee, that is child welfare committee, on account of physical, emotional or social factor beyond their control. But
He will fall within this definition.
surrender, because your lordship may kindly see one judgment I have collected, lordship, it was passed by the Honorable Karnataka High Court. Your lordship may kindly correct, lordship, that defined, even that was quashed, lordship, that Honorable Karnataka High Court lordship quashed the that charge under section 80, lordship. As there is a parents who given us the child, lordship. So that 3 definition comes into play, lordship. So your
So you have not committed any offense.
because we have.
So you can flout the juvenile justice
No, my lord,
provisions.
my lord, at least lordship, that parents have given us, even there is a letter, lordship, which I have annexed. The parents already written that we have handed over our child to them for proper lordship growing. So your lordship, in this judgment which I have annexed, lordship, which I
No,
have
that is
just
not
given,
a convincing submission.
my lord, at this stage, lordship, because we just taken.
No, if you are making that submission at this stage,
Lordship,
this
at
is,
least interim may be granted, lordship, because in the FIR itself, lordship, it is clearly stated that we have taken on adoption. Not more than any allegation from that. Lordship.
where is the child now?
Child is already handed over to the Child Welfare Committee, lordship. They have already taken, lordship, care of that child.
Your lordship, in the FIR, it is itself stated that it was rescued. The child has been, infant has been rescued by the officials of
Okay,
child helpline unit, lordship.
Just recovered, lordship.
heard Mr. M.H. Borbhuya. N.H.
Yes.
N.H. Borbhuya, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Javed Ahmed Laskar and Sadika Begum Majumdar, alias Sadika Majumdar, who are apprehending their arrest in connection with NDPS case number 68/2025 under section 93/143 within bracket 4 of BNS, read with section 80 of Juvenile Justice Act 2015. The gist of accusation in this case is that on 27th June 2025, the in charge district child protection officer of Hailakandi had lodged an FIR before officer in charge of Hailakandi police station, inter alia, alleging that on that day official of Child Helpline Unit had rescued an infant child who was given in adoption in violation of the provisions of Juvenile Justice within bracket Care and Protection of Children Act 2015. By whom? It is also alleged that the said child was illegally sold. You purchased the child.
That was one Zakaria Ahmed Mojumdar. He, as per allegation, lordship. But in first part, lordship,
What is the allegation?
against that person, lordship, that person has taken some money, lordship,
From whom?
from us, lordship. That was the allegation. But
Sorry.
that was illegally adopted by a couple. That was also mentioned, lordship, that we have illegally taken the child on adoption.
It was also alleged. Last line ki asli. Sold by one
Zakaria Ahmed Borbuye.
Zakaria Ahmed Borbuya. Stop. Learned counsel for the petitioner has submitted that the accusation under section 93/143(4) of BNSS are not directed against the present petitioner. He also submits that in this case, as the child who was adopted by the present petitioners does not come within the definition of
Definition of orphan, abandoned child,
orphan, abandoned,
surrendered.
surrendered child. Hence, the offense under section 80 of Juvenile Justice Act is also not made out in this case. He further submits that the petitioners are ready to cooperate in the investigation, and the child has already been recovered by the district
Child welfare committee.
child welfare committee. So on the other hand, learned additional public prosecutor has opposed the grant of any interim protection at this stage and has prayed for calling of the case diary. So though let the case diary be called for, raise this matter on 22nd August. So though the submissions made by learned counsel for the petitioner are not convincing, however, considering the fact that the child in question has been recovered, though the submission of the learned counsel for the petition regarding non-application of the penal provisions against them is not convincing, however, as the child in question has already been recovered and the petitioners are ready to cooperate in the investigation, in the meanwhile, they are directed to appear before the investigating officer of NDPS case number 68/2025 within a period of 10 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on interim bail of ₹30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority, list accordingly. arresting authority with following conditions, 1 and 2. Take conditions from Abhishek. List accordingly.
Visual logic, measurement timing logic.
Afterward. After something.
Item 14.
Sorry, but I was not there.
Yes.
My lord, may it please your lordship, my lord, it's a anticipatory bail, my lord. Your lordship will find the FIR at page 17, my lord.
Yes. Yes.
May I read, my lord? With due respect, I have the honor to state before you that one Gajiur Rahman, school teacher, my lord, I am the Gajiur Rahman, my lord, school teacher of so and so my academy, started giving proposal to my minor daughter, namely Surena Begum, aged about 16 years, since September 24, when she was studying at class 10 at the same school, to make relationship with him. He used to send obscene video and message to her mobile, being number so and so, and from his mobile number. Tried to bring her to the market and hotel room, threatened her about destroying her life if she doesn't make relationship with him. Also blackmail, not providing pass mark in practical if she doesn't make physical relationship with him, going to the hotels, touched her, calling her at the office room when she was alone. Proposed
Also, Mr. KK Das, learned additional public prosecutor, considering the accusation made in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary. Also, issue notice to respondent number 2 in pursuant to the notification, prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 14th of August. List accordingly.
my FIR diary.
No, that we will believe. Even if that is there, we have to verify the truth, the truthfulness of the accusation against you. 14th.
I'm okay.
Item 16. Anticipatory bail application. Lordship has already granted bail to the co-accused. So Lordship will kindly come to page 13, my lord, the FIR. Lordship, remember this case, my lord. 5 kg of beef was found in a hotel, my lord. The wife was arrested. The husband was not arrested, my lord. They were employees in the same hotel, my lord.
Your
And the
husband,
my lord. Wife has already been granted bail by your lordship. At page 18, my lord. Hotel is owned by one Naushad Ali, my lord. We have put it on oath, my lord. We were working there as employees, my lord.
how much beef?
5 kgs, my lord.
Do you have the order of the?
My lord, I have annexed it, my lord. Page 19, my lord. Page 18, my lord.
Yes. Let him appear. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. KK Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Baser Ali, who is apprehending his arrest in connection with Bongaigaon PS case number 164 of /2025 under section 299 of BNSS. 299 of BNS, read with section 13 within bracket 1 of Assam Cattle Preservation Act. Where is the bail order?
Page 18, my lord.
Code para 3 from page 19. Learned counsel for the petitioner has submitted that the petitioner is only an employee of the hotel from which the seizure of 5 kgs of beef meat was made. He submits that the wife of the petitioner, who was also an employee of the said hotel, was arrested and has already been granted bail by this court on 21/7/2025 in bail application number 2284/2025. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation, and hence he prays for allowing the petitioner to go on anticipatory bail. On the other hand, learned additional public prosecutor has objected to grant of bail and prayed for calling of the case diary. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Stop. It appears on perusal of the records that the petitioner and his wife were working in which hotel?
Taj Mahal Hotel, madam.
In Taj Mahal Hotel, from where 5.232 kgs of suspected beef was seized. It also appears that the wife of the petitioner has already been granted bail on the ground that the suspected beef meat was already seized and custodial interrogation of the and her custodial interrogation may not be necessary considering the nature of offense involved in the case. As the co-accused has already been granted bail and the petitioner is ready to cooperate in the investigation. This court, considering the nature of offense involved, as well as the fact that the suspected beef meat has already been seized, is of the considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of Bongaigaon PS case number 164 of 2025. Stop. In view of above discussion, the petitioner this anticipatory bail application is disposed of with a direction to the petitioner to appear before the investigating officer of the aforesaid case within 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions 1 and 2. This anticipatory bail application is accordingly disposed of.
19.
Eight people. This is an anticipatory bail application, my lord. Now, my lord, the FIR is at page 19. Lordship has already dealt with this case. And in respect of serial number 1, 2, and 3 at page 19, Lordship was pleased to reject the bail application. Now, my lord, if your Lordship should kindly come to page 20, why I am seeking anticipatory bail is, my lord. Page 20 on the top. The charge started at 10:30 a.m. under the leadership of officer in charge of Sonapur PS ACP, Sonapur in presence of above witness. During the charge of room number 1, 3, and 8 on first floor of the old building of Club Nirvana, the following individuals were found. So, my lord, whatever was recovered was from their room, my lord. And actually, my lord, this Prithvi, yes, Prithvi Infrastructure and Estates LLP, my lord, of which, my lord, Nirvana is a unit. They look after the, my lord, the restaurant and the other parts. My lord, we have got nothing to do with, my lord.
But
the-
you are the owner,
and
co-owner.
owner. This was not recovered from our, not even from our conscious possession. The petitioner number 1 is the wife and petitioner number 2 is the husband. But we are respectable family in the society, my lord.
No, against Mr. Pawan Sharma,
Yes.
there are materials in the case diary.
Of course, to the lordship must be.
I have gone through the case.
Yes. So in that case, my lord, in respect of Pawan Sharma, lordship will call for the CD, my lord. And in respect of the
Case
wife,
diary is there.
We have received those.
Case diary is with you.
Yes.
lordship will go through the CD, my lord. But my case was, my lord, nothing was recovered from Pawan Sharma or from her wife. It was recovered from the wife, sorry, from the room number 1, 3, and 8, where these were the borders, my lord. The gentleman, 2 persons from Mizoram, all from Mizoram, 3 persons. That we have clearly stated. And my lord, we are respectable, we are having roots in the society. Why should we tell-
Accusation against the petitioners are also under section 143 of BNS,
Pawan Sharma, my lord.
Pawan Sharma. The FIR itself discloses somewhere.
It relates to Caesar only, my lord. There is a statement. My lord, I as a owner, my lord, we do not look after the day-to-day administration, my lord.
Yes.
At page number 21, my lord, it has been found that the above named accused persons in collusion with the owners and club management. It's a general statement, my lord. No specific act has been ascribed, my lord. My lord, that we are running a gambling activities, my lord, at least FIR does not disclose any, my lord, indication. Yes, from their room, something were recovered that we are not disputing. And what a order or a lord occupant that does inside the room, that to that we may not be responsible. I am the owner, I stay somewhere else. I live in Kharbuli. My only thing is, my lord, whether in the circumstances my custodial interrogation is necessary. I'll definitely cooperate with the investigating agency, my lord.
Okay.
My humble submission is, my lord, lordship will call for the CD, my lord. And lordship will satisfy itself regarding, my lord, the veracity of the allegations and counter allegations. At the end of the day, my lord, whether my custodial interrogation in the facts of the case is necessary. And already, my lord, the manager and the occupants of the rooms have already been arrested and they are in custody. I'll cooperate. My lord.
Yes, Mr. Sharma.
These factors, lordship, already have been considered by your lordship.
Against Rupa Sharma, what is the?
Chief Lordship kindly takes up the earlier bail application 2290/25 in paragraph number 21. Lordship has taken care of all these arguments. Regarding the role of the owner or Pawan Sharma.
No, against Rupa Sharma.
Yes, paragraph 21, if Lordship, please. There are materials in the case that which indicates complicity of the owner of the club Nirvana Resort, namely Pawan Kumar Sharma, in the alleged offence under 143 of the BNS 23 and the various provisions of Assam Games and Betting Act 1970. One of the victim girls whose statement has been recorded under 183 of the BNSS 2023 has categorically implicated the owner.
Was sent to this court on day before yesterday, and it is not updated. Hence, he prays for calling for an updated case diary so as to consider the allegations against the petitioner number 1. Stop. I have considered the submissions made by learned counsel for both these sides and have gone through the case diary. I will go through the case diary and pass. Give me the case diary.
Yes. Deep Lord.
Item 25.
This is the case, my lord. Here, my lord. Petitioner was arrested, my lord. In this case, my lord. 31/2025. There is a my flag mark.
30.
1/2025. Yellow flag mark, my lord. A petition has been filed, my lord, for judicial interrogation of the accused. I am not on that, my lord. Simple case, my lord. 47/48 notice is not available, my lord. I was not communicated ground of arrest, my lord. And nothing has been recovered from my possession, my lord. In this case, my lord. Co-accused, my lord, considering 47/48, release on bail, my lord. This is the order, my lord. Motive Rahman is released on bail, my lord. Other, I am relying, my lord. In this case, shown errors, my lord, shown errors, part was also not followed, my lord.
Where are the notices? What is this?
The husband, my, I have made also, not necessary, my lord. Motive Rahman, everything has been discussed, my lord.
Your main plea is that no grounds of arrest were
And as
furnished.
communicated.
Where are the notice?
Notice is not available.
Notice is not. Have you furnished?
This is the order, lordship. One is orders pass on 4/6/25. This is the order.
My lord,
After showing him arrested in this case, have you furnished notice? That is violation.
Chief,
Yes, you may make your submissions.
Lordship, his name was shown as absconder in the final complaint, lordship. In between, lordship, he was arrested in another case, lordship, on 12/12/24, lordship. So, lordship, he is involved in 2 cases.
may I submit, my lord? Debasis Pal was, sorry.
Your main plea is that is not followed. What you want to submit?
Debasis Pal was arrested. Debasis Pal has said nothing against me, my lord. If your lordship go to the statement, I have gone to the, my lord. Only there is a phone call with Motiur Rahman, my lord, who is released on bail. I have a CDR analysis, there is a phone call between Motiur and me, my lord. No monetary transaction took place, my lord. And Debasis Pal has said nothing. I am not on merit, my lord, 47/48, my lord. It is-
That you are admitting that these notices were not given. Yes.
Page, lordship, point number 5. I want to take this.
Second page, which page? Yes,
Point number 5, lordship.
yes.
Also seen petition number so and so filed by Kaushik Sarkar, Intelligence Officer, NCB Guwahati, represented by learned special so and so, wherein it is stated for Soner's order of the accused Sakidul Haq, who is presently at Central Jail Guwahati in connection with NCB crime number 9/24. It is stated that during investigation, Sakidul Haq used the name of Saidul Mama for illegal business of methamphetamine. Accused person, Motia Rahman and Devasis was stated in their voluntary statement the name of the Sahidul Mama and his mobile number so and so. It is stated that in the petition that Sakidul Haq Mama is the associate of Motia Rahman and Rakesh so in the illegal business of methamphetamine tablet, who is one of the receiver of the 3.389 kgs of methamphetamine tablet along with the Motia Rahman and Rakesh So. Previous analysis shows that Sakidul Haq Mama communicated 99 times with Siv and 47 times with Motia Rahman within 1 month from his mobile phone so and so. Total 6 notices under section 67 of NDPS Act were served onto Sakidul Haq Mama, but he did not appear at NCB Guwahati to record his statement. Rather, he applied for anticipatory bail before the Honorable Guwahati High Court. The final complaint has been filed on 27/8/24 within the stipulated time frame, and Sakidul Haq Mama was shown as absconder. On 12/12/24, Sakidul Haq Mama were arrested in connection with NCB crime number 9/24 and is presently lodged at Central Jail, Guwahati. Accordingly, IO Kaushik Sarkar NCB Guwahati has paid for sworn arrest of accused Sakidul Haq Mama in connection with NCB crime number 2/24. Heard both sides and prayer was allowed. So, Lordship, it cannot be denied that involvement is not there. This involvement is there, Lord.
No, but have you complied with the notice? Heard Mr. N.N.B. Chaudhary, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Sakedul Haq, alias Shakedul Haq, who has been detained behind the bars since 16/1/2025 in connection with NDPS case number 300/2024 under section 22C/29 of the NDPS Act 1985, corresponding to NCB crime number 2/2024, pending before the Court of Learned, Additional Session Judge number 5, Kamrup Metro, Guwahati. The learned counsel for the petitioner has submitted that in the aforesaid case, the NCB had filed final complaint under section 22C/29 of the NDPS Act, making accusation regarding possession of commercial quantity of methamphetamine. He submits that the petitioner, who was detained behind the bars in connection with NCB crime number 9/2024, was shown arrested in the aforesaid case, that is NCB case number 2/2024, within bracket NDPS case number 300/2024, on shown arrested on 12. On which date? Mr. Yes, no, Mr. Chaudhary, when you were arrested?
As per me, arrested on my lord, 17/1/2016, no? 16/1/2025, because there is a remand order is there, my lord. You are sent remanded to the case. 300, you follow the go to the case record, my lord.
Shown arrested on Nalagi, shown arrested in the said case. However, no notice under section 47 of the NDPS of the BNS was served on him when he was arrested in the instant case. Neither any notice to any of his relatives were served under section 48 of BNSS. Stop. He therefore submits that there has been a violation of his constitutional rights guaranteed to him under Article 22 within bracket 1 of the Constitution of India, as well as statutory rights under section 47 of the BNS. And he submits that in pursuant to the directions of the apex court in the case of which case you are relying?
I am relying my lord.
Vihan Kumar versus State of Haryana, reported in 2025 SCC Online 269. His arrest has itself become illegal, and on that count, he is entitled to get bail. On the other hand, learned counsel for NCB, Ms. M. Deka, has vehemently opposed the grant of bail to the petitioner on the ground that complicity of the petitioner is indicated in the materials available in the case diary, on records. Stop. She submits that since the quantity of contraband seized in this case is commercial quantity, the embargo of section 37 of the NDPS Act 1985 is applicable to this case. She also submits that when the petitioner was behind the bars in connection with NCB crime number 9/2025, the Court of Learned Additional Session Judge number 5, on an application filed by the investigating officer, had allowed the petitioner to be shown arrested in connection with the NCB crime number 2/2024, 2025, 2 of 2024 or 2025?
2024, man.
2 of 2024 on
Application on 30 months.
this order dated is
Your lordship kindly look to the order dated 16/1/2025.
no. What is your submission, Ms. Deka? When he was shown arrested by this order on 4/6/2025. Stop. However, she fairly submits that no notice under section 47 or 48 of the BNSS could be found in the case record, and there is no indication anywhere that any such notice were served on the petitioner when he was arrested in this case. No. It is no longer res integra that at the time of arrest of an arrestee, there is a constitutional requirement of furnishing the grounds of arrest to such an arrestee. And if same is not done, his arrest itself gets vitiated, and on that count itself, such an arrestee is entitled to get a bail. In the instant case, in the instant this is applicable even in case where a person is shown arrested after obtaining the order of competent court to show a person arrested in a specific case. The arresting authority is duty bound to furnish grounds of arrest to such an arrestee, and also to serve notice under section 47 and 48 in such cases. However, nothing of that sort was done in this case. Hence, there is an apparent violation of the constitutional mandate of Article 22 within bracket 1 in this case, which in the considered opinion of this court has rendered the arrest of the petitioner illegal, and on that count he is entitled to get bail. How much contraband was there?
Wait, 3.89
KG.
3.389.
In view of above, the petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the trial court with following conditions. Condition 1, 2, 3, 4, 5. This bail application is accordingly disposed of.
Section 22C, 27A also there.
22C/27/29.
29.
Accusation of 22C, 27 and 27A and 29. Okay. This bail application is accordingly disposed of.
Lordship has already dealt with subject matter of the case, that is relates to fake appointment. Here, Lordship petition is, I have cited my ground of apprehension at para number. At para number 3, I have cited the ground why the reason of my apprehension. May I take your lordship to that?
Yes.
Para number 3 of my petition, lordship. Para 3, that the petitioner most respectfully submits that he has no connection.
Case diary is available.
Or else, that they has confirmed, we have to enter in the office, because it is in motion stage, we have not.
But case diary must be available. Case diary is available.
Today,
Ajit,
We can dispose it of today, either allow or reject after going through the case. Case diary perhaps is with me.
have to make a call in the office. No.
What is the police station case number?
Slight-
You find out. Or let us fix it on tomorrow. Heard Miss T. Som, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, who submits that the case diary of CIDPS case number 4/2025 may be available in the court itself, and he prays for some time to inquire the same, and also prays for listing this matter tomorrow. The prayer is the day after tomorrow. Tomorrow, Friday.
Friday.
Oh, okay, tomorrow. Tomorrow, list accordingly. For if the case diary is available, same shall be produced by learned additional public prosecutor.
26.
Commercial quantity lordship 21.605 kgs of ganja lordship. the ground before appearing this court lordship that no ground of arrest were furnished in the notice lodged. Is that case lordship? On the last occasion lordship, the learned.
Is there? Yes,
On the last occasion, learned PP has submitted from case diary lordship that on arrest memo, the grounds of arrest were there lordship. But the arrest memo was not furnished to us lordship. We have lordship, we have obtained a certified copy of the arrest memo. But on the perusal of the arrest memo lordship, we have not found any specific grounds of arrest lordship. It is a lordship might have that they gone lordship, and this is the original copy of the certified lordship. Yeah, lordship, as you have submitted lordship, no grounds of arrest has been seen in the lordship arrest memo. The notice we have already annexed in the petition.
yes.
Yes, Lordship. Here, if you look into the forwarding, Lordship, it is 2025. And IONET is also there, 22/2/2025.
Where,
And grounds are also there. and
where? In the forwarding report.
Not in forwarding, I am stating that Lordship, he was arrested and forwarded on 22/2/2025. And IO note is also on the same date. I'm emphasizing on that, Lordship.
What is the note?
It is noticed there, the ground of arrest has been communicated to her as well as her relative as per arrest and inspection memo and notice under section 47 and under section 48 BNSS. So Lordship was on the another earlier occasion asked me or made a query to me, Lordship, whether any note is there or not. It is there, Lordship.
No, note will not suffice.
Note is also there, Lordship, and grounds are also there. Lordship, may kindly tell me, Lordship.
Grounds where it is mentioned.
Grounds are-
Whether arrest memo was served on.
It is there, Lordship. In the note also, in the note itself, it is stated. In the note. Signature is also there, Lordship. Lordship may kindly look into the flag marks that I have. It is clearly stated that arrest memo and inspection memo, it is there. Clearly written, Lordship.
Yes. The note of IO is there. Yes, Mr. Munir. Mr. Munir.
That I can understand, lordship will kindly see page 15 lordship.
Page 50.
The forwarding report lordship, kindly see the enclosure lordship. You see the enclosure lordship. There no mention about this lordship, the notice and arrest memo lordship.
What it means?
So normally what happen lordship in all the forwarding report, we can see lordship, the arrest memo, the notice, all are.
No,
enclosed along
no,
with the-
question before us is whether grounds of arrest was furnished to you in writing, either in 50 notice or otherwise.
It is there, Lordship.
Arrest memo, we have already furnished there. We have obtained certified copy from the court lordship, as you have submitted on the last occasion. That the grounds of in the arrest memo, grounds of arrest were mentioned lordship. As it is a document of the case diary lordship, we could not inspect each lordship, so we have went there lordship in the lower court lordship and we obtained a certified copy and you can count.
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. KK Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Amina Khatun, who has been detained behind the bars since 22/2/2025 in connection with Bashishta PS case number 118/2025 under section 22B, under section 20B2C of NDPS Act. The gist of accusation in this case is that the petitioner, that on 21/2/2025, Biplab Roy had lodged an FIR before the officer in charge of Bashishta Police Station, inter alia, alleging that on receipt of any information through reliable source that the present petitioner would be carrying present petitioner has stored suspected ganja in her rented house situated at Kali Mandir Path, Beharbari, a search team was conducted and a search operation was made. During search of the house of the present petitioner, how much
Lordship,
21.605 kgs of suspected ganja was recovered from the possession from the house of the present petitioner. The learned counsel for the petitioner submits that the petitioner is seeking bail in this case mainly on the ground that no grounds of arrest were communicated to the petitioner when she was arrested in connection with this case. It is submitted by learned counsel for the petitioner that though notice under section 47 of the BNSS as well as notice under section 48 of BNSS were served on the petitioner and her relative. However, said notices do not contain any ground of arrest. He also submits that even the arrest memo a copy of which is available in the records, and the petitioner has even the arrest memo of which the certified copy has been produced by the petitioner by the learned counsel for the petitioner before this court, does not mention any ground of arrest. He therefore submits that in this case, there has been violation of the constitutional mandate of Article 22 within bracket 1 of the Constitution of India. And on that ground, on that count, he is entitled to get bail. In support of his submission, Putul Vihan Kumar Dev, in support of his submission, he cites the ruling of Apex Court in the case of Vihan Kumar versus State of Haryana and another reported in 2025 5 SCC 799. Stop. On the other hand, learned additional public prosecutor Mr. K.K. Das has vehemently opposed the grant of bail to the petitioner on the ground that the quantity of contraband involved in this case is of commercial quantity, and hence the embargo of section 37 of the NDPS Act is applicable to this case. He also submits that the requirement of Article 22(1) of the Constitution of India is to furnish grounds of arrest to an arrestee at the time of his arrest in writing, and same has been duly complied with in this case. He fairly submits that though in the notice under section 47 and 48, no grounds of arrest have been, no ground of arrest has been mentioned. However, in the arrest memo prepared at the time of his arrest, the grounds of arrest has been mentioned in detail, a copy of which is available in the case diary. Learned additional public prosecutor also submits that on the said arrest memo, the signatures of the petitioner as well as impression of her right thumb has also been obtained. He also submits that there is also an endorsement in the case diary made by the investigating officer that at the time of arrest, that after the arrest of the present petitioner, the said arrest memo was served on the petitioner. He therefore submits that there has been no violation of the constitutional mandate of Article 22(1) of the Constitution of India in this case, and therefore opposes the grant of bail to the petitioner. I have considered the submissions made by learned counsel for both sides and have perused the case diary of Vashishta PS case number 118/2025 under section 20B2C. No, Vashishta PS case number 118/2025. Stop. The question to be decided in this bail application, whether the petitioner was furnished with the grounds of arrest, in writing, soon after his arrest, as required under Article 22 (1) of the Constitution of India, as well as under Section 47 of the BNSS. Stop. On perusal of the case diary, ... Chamber. I'll dictate the remaining part in chamber.
Item 27.
Yes.
So for lordship, but that has not been received. I've checked the office note.
The records have not been received. Will issue reminder.
Consideration, lordship. The petitioner is in custody since 2 years, 1 month and 16 days.
Status. What has been called for? Scan copy of LCR. Okay. Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 25/6/2025, it appears that the scanned copy of the trial court records have not yet been received. Issue reminder for the same. Let this matter be listed. 18th. 18 is the it is the shortest available date for NDPS cases. 18th August.
Item 28.
May it please, well, it's a charge sheeted case, my lord, under POCSO, madam.
Yes.
My lordship will turn to page 17, my lord. 17.
When you were arrested,
I got arrested, my lord, on 28/05/24.
for how long you are within the law?
Today, my lord, 428 days. My lord.
What is the status of trial?
My lord, the charge sheet, my lord, 10 numbers of witnesses are cited, my lord, out of which, my lord, 6 were examined, my lord. Victim also examined, my lord. Victim and the informant. My lord. If your lordship have a look at, my lord, page
17.
Yeah.
Learned amicus curiae appearing for respondent number 2. This application under section 483 of BNSS has been filed by the petitioner, namely Shri Charan Mandal alias Monu Mandal, who has been detained behind the bars since 28/5/2024, within bracket for last 428 days in connection with POCSO case number 88/2024 under section 376 IPC 365/376 IPC, read with section 6 of the POCSO Act 2012. In this case, the petitioner is facing a trial in the court of learned special judge POCSO for charges under section 365/376 IPC and section 6 of the POCSO Act. Learned counsel for the petitioner has submitted that the trial conditions. This bail application is accordingly disposed of.
DPO.
29. 29 lordship, office note dated 25/7/25 reflects that service report is still awaited lordship.
None has appeared for the petitioner on call. Learned on perusal of the office note dated 25/7/2025, it appears that the service report of notice issued to respondent number 2 has not yet been received. So, learned additional public prosecutor is requested to get information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date. List this matter on 11th of August.
Item 30. In item 30 lordship, amicus may be appointed lordship. The informant approached our office today morning lordship and they asked me to appoint an amicus. They will not be appointed.
Heard Mr. S. Nath, learned counsel for
It has already been
what?
100 days, madam.
But right of hearing is there. We will appoint an amicus and it is. What is the status of the trial?
Restriction.
Lordship,
But,
probably the scanned copy also not received probably. Lordship. There must be an office note. Lordship.
If you don't have instructions, then we have to call for the status. Heard Mr. S. Nath, learned counsel for, what is your case, Mr. Nath?
Land dispute between the parties.
False.
False,
Yeah,
madam.
okay.
False allegation has been.
Then we have to peruse the case. Scan copy. Heard Mr. S. Nath, learned counsel for the list of amicus. Counsel for the petitioner, as well as Mr. B. Sharma, learned additional public prosecutor, who submits that he has been requested by the informant of this case to get an amicus Curie appointed for him to defend respondent number 2 is male or female? Get for her to defend her cause in this bail application. Stop. Accordingly, suggest a name, Mr. Sharma. Accordingly, Miss M.K. Brown is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner shall furnish copy of bail application along with annexures to the newly appointed amicus curiae. The registry shall reflect the name of Miss M.K. Brown as amicus curiae for respondent number 2 in this case in the cause list henceforth. Stop. Let the scanned copy of the records of the trial court as well as scanned copy of the case diary be called for from the trial court. Registry to issue requisition for sale. 21 August. Let this case be listed on 21/8.
31 Lordship, charge sheet has been submitted.
POCSO charge sheet has been submitted. Go before the trial. No, charge sheet has been laid. You go before the trial court. Heard, Miss, what is your name? A. Begum, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for in this case, however, charge sheet has been laid bearing charge sheet number
30/05/25.
in view of this fact that charge sheet has been submitted in this case, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file regular bail before the said court, if so advised.
Item 32. Here also Lordship, the service report is still awaited, Lordship. It is a Lordship, and the CD also not received.
Yes,
Is it was called by Lordship?
heard Mr. S. Arias, learned counsel for the petitioner. Office note dated 25/7/2025 shows that service report of the notice issued to respondent number 2 has not yet been received. Learned additional public prosecutor is requested to get information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date fix. Learned additional public prosecutor also prays for some more time for producing the case diary. The prayer is allowed. When? Let this case be listed on 21 August.
Deeply obliged.
Item 33.
Lordship, 483 application, Lordship. Allegation is under Arms Act and Explosives Act.
Arms Act and
Explosives Act. Lordship, two handgun and one grenade was seized in the year 2015, Lordship. Thereafter, Lordship, the accused petitioner was granted bail in the year 2023, Lordship. Earlier scanned copy of case record was called for, Lordship. 13/2/2023, his bail was granted, Lordship. Thereafter, Lordship, annexure to page 15, Lordship. 23, 2020. 13/2/2020. 13/2/2020. Thereafter, Lordship, since his co-accused
Putul. Yes. Yes,
His co-accused was not found, Lordship. Hence, the trial has proceeded separately against him, Lordship.
okay.
Now, Lordship, by order dated 16/1/2025, on the strength of PNA, Lordship, he was again arrested, Lordship.
But you defaulted, you must have been defaulted.
Yes, Lordship. Yes, on the strength of the PNA, he was again arrested in the year 2025, Lordship. Thereafter, he has been behind the bars since 195 days. Now, trial has proceeded separately, Lordship. However, the case is pending in the FTC court, First Trade Court, Gosaigaon, Lordship, Additional Sessions Judge. However, due to vacancy, Lordship, since the last 4 months, the trial has not proceeded further. It's in the stage of framing of charges, Lordship, right now. Lordship. He is behind the bars since 195 days.
What is your submission? You defaulted once. If you are given bail, you will again jump bail. What is the assurance?
My only prayer is that he will appear, Lordship, for the trial, Lordship. He will appear under.
Why
any
this
strict
court
terms and
should
conditions.
believe you once you have not complied with
He's a
the,
resident of the same place, Lordship.
but still you defaulted bail.
Definitely, Lordship, there was default due to, Lordship, since long time, Lordship. Since 2015, this case, he was appearing, Lordship. Since 2015, he was behind the bars, till 23, Lordship. Therefore, thereafter, Lordship, the case had not proceeded, Lordship. 1-2 times, Lordship.
When you were arrested?
I was arrested in the year 2015, Lordship.
No, after,
Lordship, currently, I was arrested on 16/1/2025. That is annexure, Lordship, 15, page 15, sorry. Page 15 on the strength of PNA. Lordship, earlier, he did not have any engaged lawyer at that point of time.
yes,
Co-accused, my lord, yes,
his case has been split.
split. But he is not yet, my lord, appeared before the court, NBW also issued against him. Now, in similar footing, he also defaulted, my lord. Otherwise, yes, 15 to 23, he was in jail. But in the trial stage, my lord, he defaulted, my lord.
Earlier you were granted bail on 13/2/2023.
Yes.
Strict condition, my lord, otherwise he has
Heard Mr. P.K. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Prig Brahma alias Gabala, who has been detained behind the bars, since
16/01/2020.
16/01/2025 for how, within bracket, for how many days?
Lordship, till today, 195 days.
For last 195 days in connection with sessions case number P2/35/25 corresponding to Gosaigaon PS case number 152/2025 under section 25 within bracket 1 capital B bracket close bracket A of the Arms Act read with section 4/5 of the Explosive Substance Act. Learned counsel for the petitioner has submitted that the petitioner is facing a trial before the court of learned. Which court?
Lordship, it is Additional Sessions Judge, FTC, Circuit Court, Gosaigaon.
Before the court of learned, additional session judge FTC, Gosaigaon, for offenses as referred to herein before. Stop. He submits that in the year 2023, that is on 13/2/2023, the petitioner was granted bail by the trial court. However, as one of the co-accused person, as the attendance of one of the co-accused persons could not be procured in the trial did not proceed. The trial did not proceed. And the petitioner defaulted in appearing before the trial court. Learned counsel for the petitioner submits that the trial court issued non-bailable warrant of arrest as well as proclaimed him as an absconder and issued orders for attachment of his property. And in pursuant to the non-bailable warrant of arrest, he was again arrested on 16/1/2025. So learned counsel for the petitioner submits that the trial court is presently vacant as no presiding officer has been posted there for last 4 months. He submits that the petitioner is an inhabitant of where? Kokrajhar district, and he is ready to face trial. And he may be allowed to go on bail with any condition which is deemed fit by this court. On the other hand, you are opposing on the other hand, learned additional public prosecutor, Mr. K.K. Parashar, opposed the grant of bail on the ground that the conduct of the petitioner does not justify granting him bail once he has jumped bail which was granted to him by the trial court. I have considered the submissions made by learned counsel for both sides. It appears from records that once the petitioner was granted bail by the trial court, however, thereafter, trial did not proceed due to absence of the co-accused. It also appears that case of the petitioner was split up from the case of the absconding accused. It also appears that presently it is vacant.
Yes.
I'm not verifying. I'm relying on your submission.
Yes,
It
it's lying vacant. Yes, the presiding special judge, was it additional session judge, post Kokrajhar also POCSO, that is also lying vacant.
Presently, no presiding officer has been posted in the court where the trial of present petitioner is pending. Considering above circumstances, this court is of opinion that if the petitioner appears regularly before the trial court and cooperates in the trial, his custodial detention may not be necessary. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of lying amount, subject to the satisfaction of the trial subject to the satisfaction of learned. Who is
It's sessions judge Kokrajhar.
learned session judge Kokrajhar with following conditions, trial conditions. With above observation, this bail application is hereby disposed of.
DPO.
Those cases are period 90 days, but 2 days, about 60 days, my lord. An official secret act, my lord.
He is a mason by profession. And from education that point of view, he talks.
CD is there. What is the allegation?
Education that point of view, he had some, what happened, my lord? He got some phone numbers in the Facebook, social media, my lord. But in order to give some loan, in a contact these the numbers. He contacted, ultimately, my lord. Thereafter, they demanded rupees 10,000 to pay, so he stopped talking to them, my lord. Those numbers belong to someone who belongs to Pakistan.
Case diary would be required.
This is the addiction. But now this person, he has nothing to do, my lord. Only he got in the social media and that's why he contacted.
Case diary may be required. Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. A. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who seeks some more time for producing the case diary. The prayer is allowed. Let this case be listed on 14th of August.
35.
What is the case?
It's a case of NDPS, my lord, and the ground taken in this case was, my lord, a total ganja, my lord, recovered, my lord, 20 kilo, 0.60 gram. And so far the ganjas were packed in a, my lord, carton, my lord. It may come down also, but and
You
secondly,
pray before the trial court.
charge sheet has been filed, my lord.
You will be,
Scan copy.
but you will be provided with the copies of documents. There, every record will be there.
The 47 and 48 notices are not.
Take plea before the trial court.
What should they call for the scan copy? my lord?
But trial court may grant you bail if what you are submitting is right. There is a possibility. You may convince the trial court also. Heard Mr. N.J. Datta, learned it is only point some grams.
Yes, my lord. That is the tape, my lord, and the carton, my lord.
Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This, who submits that though the case diary was called for, however, charge sheet has been laid bearing charge sheet number
145/2025 dated 2020, that is 06/2025.
stop. In view of the fact that charge sheet has been laid, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file regular bail before the said court, if so advised.
46.
NDPS, yes,
Case diary is there. Yes. What-
down that 47 and 48 has not been communicated.
47 and 48.
Annexed lordship. The purported notice on page 21.
Which page?
Page 21. Page 21. Okay, kindly. Page 21. Annexure 4.
Yes.
My lord, here, lordship. Notice of information of ground of arrest, bracket 48 of BNSS. So kindly see the address, address is to Arnab Goswami or Arup Goswami, chairperson of Thana level Nagorik Committee of Panmada. Lordship, this person, who is this person, the petitioner does not know either the petitioner, family member, nor this person, nothing. Then Lordship, so in this letter, notice Lordship, there is no date also mentioned. Moreover, Lordship, in the first line, Lordship, the second line is information to apprehended person on grounds of apprehension and right to pay.
If
No,
it is-
you have covered the microphone.
Lordship, the second line from the top, Lordship. Information to apprehended person on grounds of apprehension and right to bail. If it is Lordship, the Lordship considered as Lordship the notice for 47, then the address must be the petitioner. And if it is considered.
No,
as
it is not notice under 47, it is 48.
Lordship, 48 is that Lordship, then this person Lordship, the petitioner does not, the petitioner is
No, where is 47 notice?
Nothing, Lordship. No notice has been given.
47 notice is there. The signatures are there. What is the name of the arrested person?
Parvina Khatun Bibi.
Parvina Khatun Bibi. There it is Parvina Bibi.
Okay.
And Lordship, most interestingly, Lordship, the FIR, Lordship, the FIR, if your Lordship see the FIR page 14, Lordship. FIR, Lordship, the petitioner was apprehended on 7/5/2025, Lordship. And he was found arrested, Lordship, in arrest memo, page 22, on 8/5, Lordship. Next day, Lordship. And in this arrest memo also, Lordship, the FIR, it is clearly that mentioned that there, when she was charged, Lordship, and apprehended, Lordship, 3 witnesses were there. And in arrest memo, no independent witnesses has been, Lordship, their Lordship. Whereas in the Lordship, the BK Bosu judgment, Lordship, in paragraph 35(2), Lordship, the there is, it is required, Lordship, for I'm giving up.
Now, what is your submission?
My submission is, Lordship, that the section 47 has not been complied. 48, if this is 48, Lordship, this, when this is the page 11, Lordship, if this is 38, Lordship, then this person who is Arup Goswami, Lordship, she does not know whether her family members also does not know she is from Kuchbihar, Lordship. And this Arup Goswami is from Guwahati, Lordship. So she does not know this person also, or his family members does not know this person. So by this, Lordship, notice, Lordship, section 48 also not complied, Lordship, which is also otherwise mandatory, Lordship. And as part the Lordship behind judgment, Lordship. And the arrest memo, Lordship, in DK versus Speed, Lordship, paragraph 35(2), Lordship.
48 notice is there in the case diary.
To Lordship, Arup Goswami.
In paragraph 35(2), Lordship, here is mentioned that Lordship, that the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness.
Where are you reading?
Lordship, page 435,
Para?
para 35(2), Lordship.
Yes.
Okay, that the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested at least one witness, who may either be a member of family of the arrestee or a respectable person of the locality from where the arrest is made. So, Lordship, if your Lordship peruse the arrest memo, Lordship, no such witness is there. It is true that the petitioner family members are not there, but if we peruse the FIR, Lordship, in FIR it is stated 3 names, Lordship, that during the search page, Lordship 15, during the search, Lordship, 3 members was there, Lordship, in Guwahati railway station. if she was apprehended here, the arrest memo maybe attested some, at least one person. Lord. So it is clear that this memo also prepared later on.
Why notice under 48 was given to Arup Goswami? Police has to inquire the accused, who is your relative or who is your nominated person to whom information is to be given. And to that, there must be some endorsement. You go through the case diary. You have to find out why notice was given to Arup Goswami.
Only request, Lord.
Day after tomorrow. Heard Mr. AMS Majumdar, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner is seeking bail mainly on the ground that the notice under section 48 was not served on the relatives of the petitioners at the time of his arrest as required under law. He submits that the said notice was served on one Arup Goswami, who is in no way connected with the present petitioner. He also submits that the arrest memo prepared at the time of arrest of the petitioner does not contain any witness who was present when he was arrested as mandated by the apex court in its judgment in the case of D.K. Basu versus State of West Bengal, reported in 1997, 1 SCC 416. Stop. Learned additional public prosecutor, on the other hand, submits that though the case diary is available before the court, he needs some time to go through it and to make a counter submission against the submissions made by learned counsel for the petitioner and seeks some time for the same. The prayer is allowed. Let this case be listed on first of kiman ase?
180.
On 1st of August.
Item 37.
Lordship, the petitioner has been in custody for 30 days as of today, Lordship. Since the 6 kg of suspected cook meat has already been recovered. So, Lordship, no further custody.
How many days?
30 days, Lordship.
30 days. 30 days is long period for us. Heard Miss, what is your name?
It's
Heard Miss P. Das, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Rahima Khatun, who has been detained behind the bars since 1/2/2020. Which is the date of your arrest? You have mentioned it wrongly. 1/7/2025 for last 29 days in connection with Gosaigaon PS case number 88/2025. So the gist of accusation in this case is that on 1/7/2025 and one Ritik Kashyap, SI of police, had lodged an FIR before the officer in charge of Gosaigaon Police Station that on receipt of an information through reliable sources that one hotel, namely Hotel Jannat, and some other hotels situated at Shimlu, Simultapur Bazaar is selling beef meat in contravention of the provisions of Assam Cattle Preservation Act, a search team was constituted and a search operation was conducted. So during search operation, 6 kgs of suspected cooked beef meat was recovered from the hotel of the present petitioner. You are the owner?
No,
Then
worker lodging.
from the hotel where present petitioner, from the Hotel Jannat, stop. The petitioner was apprehended from the said hotel. Stop. Learned counsel for the petitioner has submitted that the petitioner is an employee of the said hotel and has been detained behind the bars for last 29 days. She also submits that as the suspected beef meat has already been seized, further custodial detention of the petitioner may not be necessary. Hence, she prays for allowing the petitioner to go on bail. On the you have produced the case diary. Progress is there. FSL is not there. Learned additional public prosecutor has produced. You are opposing the bail. Has opposed the grant of bail and has produced the case diary of Gosaigaon PS case number 88/2025. And he has submitted that the investigation has fairly progressed and it is mainly pending for receipt of the FSL report. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Gosaigaon PS case number 88/2025. Considering the progress made in the investigation as well as period of detention already undergone by the petitioner, this court is of opinion that if the petitioner cooperates in the investigation, her custodial interrogation may not be necessary for fair completion of the trial, for fair completion of the investigation of the aforesaid case. Stop. In view of above, the above named petitioner is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned SDJM Gosaigaon with following conditions. Number 1 and 2, two conditions take from Abhishek. This bail application is accordingly disposed of. Stand back the case diary.
Malad, 57 days today.
What is the offense?
Cattle Preservation Act, Malad. Page 12 is there.
Yes, what is to be done?
57 days, 57, 60, mandatory 60 days. After getting certificate to be over, he appeared, 6 days will be over.
Heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Mr. P.S. Lakar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Amjad Ali Sheikh alias Amjad Ali Sheikh, who has been detained behind the bars since 3/6/2025 for last, within bracket, for last 57 days, bracket close, in connection with Kokrajhar PS case number 131/2025 under section 303 within bracket 2/317 within bracket 2/3717 within bracket 4/313 of BNS, read with section 13 within bracket 1/16 of Assam Cattle Preservation Act and 11 within bracket 1 within bracket small d of the Prevention of Cruelty to Animals Act. The gist of accusation in this case is that on 1/6/2025, one Deepak Kumar Chauhan, SI of police, had lodged an FIR before the officer in charge of Kokrajhar police station, inter alia, alleging that on that day, the villagers of Salbari village had detained 2 persons, including the present petitioner, on suspicion of being involved in stealing of cattle. The vehicle which was used for carrying the cattle got damaged in an accident which occurred before the apprehension of the present petitioners. Stop. Present petitioner. Only one petitioner is before. Learned counsel for the petitioner submits that the petitioner has been detained behind the bars for last 57 days and the offences which are involved in this case entails maximum punishment of 8 years only, and therefore the statutory punishment, statutory period of detention for which the petitioner may be kept behind the bars under section 487 of BNSS is 60 days. He therefore prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has submitted that though the case diary was called for, same is not available and seeks some more time for production of the same. Stop. I have considered the submissions made by both sides. Stop. Since maximum statutory period of detention under section 487 BNSS, for which the petitioner may be kept behind the bars in the aforesaid case is 60 days only, and as he has completed 57, he has already completed 57 days, this court is of considered opinion that his further custodial detention may not be necessary for fair completion of the investigation. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Kokrajhar with following conditions 1 and 2. This bail application is accordingly disposed of.
Item 50 from supplementary list.
50, 51 and 52. All are related with the same issue.
50?
50, 51, and 52.
Yes.
It is fixed for filing of submission of my written.
Okay,
submission.
you have,
I have also furnished the copy to the petitioner.
these are NDPS cases.
The other page is they have taken.
Item number 50, my lord. My additional affidavit, my lord.
You have done good labor. Yes, what is the submission?
Submission, my lord, in the arrest memo as well as section 50 and 50A, my lord. There is no ground of arrest, my lord. I am relying upon the judgment of my lord Bihan Kumar and
Okay. What is your, what, item number 50, what is the date of arrest?
date of arrest 16/11, my lord. That is after the Pankaj Bansal, my lord, judgment, my lord. That was on 3/10/23, my lord. So. Most 16/11 after the judgment.
Okay. What is your reply to the written objections?
Oral. Not submitting my written.
No, no, orally you, what is
Yes.
your response?
Response. My lord, I'm saying, my lord, the arrest memo and notice others, my lord, no ground of arrest, my lord, and what he has submitted, my lord, that the, in my lord, for red-handed, my lord, that ground of arrest is not required in writing, my lord. That is, my lord, decided in the Bihan Kumar case, my lord. And my lord, also, my lord, that Pankaj Bansal case, my lord, Ramakrishna Arora, my lord, judgment, my lord. It is referred to the Pankaj Bansal case, my lord, that brought in henceforth, my lord. So my arrest is after that the judgment, my lord. So it will not covered by the objection filed by the additional people, my lord.
Yes, Mr. Munir.
The same notice, no ground of arrest in the arrest memo 47 and 48. That's all has been annexed in the petition. Is certified copy.
Your response to his written,
So I'll
objection.
stick to Lordship Bihan. The ground.
Yes,
My date of arrest is Lordship.
What?
27/11/2024.
Item number 50,
51 Lord.
51 some. Twenty-seven,
11/2024.
how many days you are behind the bars?
I am behind about 245 days as on date.
And item number 50, next item is? Item number
52, Lord.
52.
Commercial quantity, Lord.
You are also praying for grounds of arrest.
Same ground, Lord.
What is your date of arrest?
Date of arrest is Lordship 2/12/2023, Lord.
How many days you are behind the bars?
20 months, Lord.
Okay, 1 year, 8 months.
See, I have annexed
This you have to take dictation in chamber. I'll dictate it in chamber after going through the objection filed by the public prosecutor. All,
I'm also relying Bihan Kumar case.
okay,
Para 14 and 16 is very much clear.
okay. 8, Denyota, chamber of the bus. 50, 51, 52, chamber of the bus.
Much obliged.
That we lost. My lord, yesterday the matter was listed lordship. The learned people was my lord directed to confirm whether CD, my lord, charge sheet was filed
I
lordship.
have telephonically the instructor staff, but not yet.
5 days in.
The instruction is there, but after some time,
After some time. Okay, after some. Otherwise, what?
As per his instruction, a subsidy is there.
I have instruction lordship, sheet is submitted, but the confirmation from the my lord RPP is my lord required lordship.
Okay. Let him confirm
Telephone.
after some time.
Made to this lordship. The petitioner was arrested on 4/6.
Separate written objections, they say, separate corresponding. Yes,
The petitioner was arrested on 4/6/2025. Today is 57 days lordship. Statutory period is 60 days lordship. 10 grams heroin has been recovered from the seat of the driver lordship. And the
what was recovered?
lordship
What was recovered? 10 grams.
from the seat of the driver lordship, whereas the petitioner is a handyman lordship and he had no idea about the contrabands kept by the driver lordship.
Why your prayer was rejected by the trial court? His diary is there. Yes,
Otherwise, in conscious position, this 10 gram is there, lordship.
what is the progress? Progress is all investigation, whether FSL report is. So apart from FSL, others. Okay. What is your submission?
FSL is not there, lordship. And moreover, lordship, in our position, lordship, in his position, lordship, this thing has been found. Contraband. So I object on that count.
Miss, what is your name?
P does. P.
P. Das.
A-
B. Das, learned counsel for the petitioner. Also Mr. K. Das, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Riaz alias Riazuddin, who has been detained behind the bars since 4/6/2025 within bracket for last 57 days bracket close in connection with Rongya PS case number 115/2025 under section 21B/25/29 of the NDPS Act. The gist of accusation in this case is that on filing of an FIR, now on 3/6/2025, one Ranjana Jyoti Datta, PJ Datta, SI of police, had lodged an FIR, inter alia, alleging that an information was received through reliable sources that two unknown person would be carrying suspected heroin in a vehicle bearing registration number AS15AC 9741. Accordingly, a NACA checking was arranged. During NACA checking near National Highway number 27, the aforesaid vehicle was intercepted and the present petitioner, along with one another accused, was apprehended therefrom. During search of the vehicle, 10 grams of suspected heroin was seized therefrom. Stop. Learned counsel for the petitioner submits that the heroin was recovered from below the seat of the driver of the said vehicle, and the present petitioner was working as a handyman in the said vehicle. She submits that the present petitioner is innocent and he was not aware of the presence of heroin in the said vehicle. She also submits that the petitioner has been detained behind the bars for last 57 days and the maximum statutory period of detention for which he can be kept behind the bars in the offense involved in the aforesaid case is only 60 days. Therefore, she submits that considering the period of detention, the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Rangya PS case number 115/2025 and has submitted that and has opposed the grant of bail to the petitioner. He submits that the seized contraband was found from conscious possession of the present petitioner, as he was also an occupant of the vehicle from which the contraband was recovered. Stop. He, however, submits that the investigation has fairly progressed and it is pending mainly for receipt of the FSL report. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Stop. Considering the progress made in the investigation as well as period of detention undergone by the present petitioner within bracket 57 days bracket close, this court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the investigation. So, in view of above, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned. Whose satisfaction? Which court? Learned Special Judge Rongya. With following conditions, 1 and 2. This bail application is accordingly disposed.
Item 55.
Please, Your Lordship. My lord, as on today, I am 75 days in custody, Lordship, for making a Facebook post comment, Lordship.
CD is there?
Well,
Yes. What is your submission?
Lordship, my submission is that the mobile from which the comment was made is used by my divorced wife, Lordship. And
Your mobile was with your divorced wife. Yours.
Actually, my wife divorced me, and while she went away, my mobile was also taken away by her. I have taken Lordship.
Okay.
And 75 days length of detention, Lordship. Otherwise, Lordship.
So you are saying that your wife has posted that.
Maybe, Lordship, maybe, because I do not know how to write a message. I do not know.
So even after divorce, your accusation continues. Yes, Mr.
There's a report from the before he arrested a report was called from the Facebook authority. There's a report from the Facebook authority. That post is his post, and that account was still active at that point of time, and mobile number match. After that, he was arrested. Now, as per his statement, he stated that I don't know who. I don't know. I have no idea who have written Pakistan Zindabad. I love Pakistan. Who wrote? I don't know.
But only this much was posted.
At that point of time, yes, when the
Okay, now you need his further custodial detention. Submit fairly.
Otherwise,
Yes, he, though he refused, but as per the report of the Facebook, it is done by his mobile and from his account. Maybe the mobile of another person, but account is also
Okay,
with him.
okay. Heard.
And witnesses also stated that we have seen that he has made it and he should not make this one, but his friend also, village person also, he should not make a statement like this. That is a statement of the village persons.
Okay. Heard Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Abdul Rashid alias Rashid Mandal, who has been detained behind the bars since 17/5/2025 within bracket for last 75 days in connection with Lakhipur PS case number 66/2025 under section 152/196 within bracket 1/197 within bracket 1/113 within bracket 3/299 within bracket 299 of BNS read with section 66 of the IT Act. Stop. Learned counsel for the gist of accusation in this case is that the petitioner that on 8/5/2025 Jugal Das had filed and had lodged an FIR before the officer in charge of Lakhipur police station inter alia, alleging that when information was received from Cyber Cell Gwalpara regarding uploading of an objectionable post within bracket Pakistan Jindabad, I love Pakistan, like inverted comma close, within inverted comma, in social media platform and Facebook by the present petitioner. So, and it counsel for the you made on your last appearance submission regarding 152.
There is no impact on 152.
Okay. Learned counsel for the petitioner submits that the mere posting of the mere uploading of the alleged Facebook post does not constitute an offense under section 152 of BNSS. Stop. Learned counsel for the petitioner also submits that if the offense under section 152 of BNS is left apart, the other offenses involved in this case provides maximum period of detention of 60 days only. He further submits that the mobile phone of the petitioner was with the divorced wife of the petitioner, and he had not posted the said post in the Facebook account. He further submits that petitioner has been languishing behind the bars for last 75 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor, you are has opposed the grant of bail to the petitioner and has produced the case diary of Lakshipur PS case number 66/2025. He has submitted that there are materials to indicate that the Facebook post was uploaded from the account of the present petitioner. However, he fairly submits that the investigation has fairly progressed in this case. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary which was produced before this court by learned additional public prosecutor. It appears that the petitioner has been detained behind the bars for last 75 days. And considering the nature of accusation, the said period appears to be enough to make substantial progress in the investigation. Stop. This court at this stage does not intend to make any observation regarding the fact as to whether any offense has been committed under section 152 of BNS in this case or not. Apparently, prima facie, this court is of view that the ingredients of said offense is lacking in this case. However, be that as it may, considering the period of detention undergone by the petitioner within bracket 75 days, this court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial interrogation may not be necessary for fair completion of the investigation in this case. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Gwalpara, with following conditions. Number 1 and number 2, send back the case diary. This bail application is accordingly disposed of.
Deeply opposed.
Item 41.
For ethics application.
Yes, you are on interim.
I'm interested.
She appeared. You are a lady.
Lordship.
Petitioner is a lady or
Lady, Lordship.
heard Mr. What is your name?
Equally.
D. Kolita, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioner was granted bail, interim bail by this court on 2/6/2025. And in pursuant to the directions of this court, she has appeared before the investigating officer and has cooperated in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Panbajar PS case number 118/2025 and has submitted that the petitioner has appeared before the investigating officer and her statement under section 180 BNSS has been recorded. Stop. Considering the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to her by this court on 2/6/2025 is hereby made absolute, with condition number 1 and 2 attached to the said order remaining intact. This anticipatory bail application is accordingly disposed of.
I will allow.
May I please, your lordship? It is the fourth time the city has not.
You are on interim.
No, I am not. Allegation is under section 1314 of Assam and Game that is. Punishment is less than 3 years.
Yes. What is to be done? What is the offense? One more chance.
Court occasion, interim protection may be granted. I will cooperate with the IO.
Okay, interim protection will be granted. Heard, Mr. What is your name? KK Das. No,
My name is.
M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. KK Das, learned additional public prosecutor, who submits that the case diary has not been received, though requisition for same was sent by the office of the learned public prosecutor. So learned counsel for the petitioner has submitted that this is for the fourth occasion the prosecution side has failed to produce the case diary in spite of specific direction to do so. He submits that the offense involved in this case is under section 13/14 of the Assam Games and Betting Act 1970. The maximum punishment for said offenses is
Less than 3 years.
less than 3 years. He also submits that the petitioner is ready to cooperate in the investigation. Stop. In issue reminder for the case diary. List this matter, give it 26th August. However, in the meanwhile, the petitioner is directed to appear before the investigating officer of the Rauta Police Station case number 33/2025 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with above mentioned case, comma, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, number 1 and number 2, list accordingly.
May I please, your lordship? Lordship, in this case, lordship, PRS bail, I am on interim bail, lordship. Accordingly, as per the interim order, I have already appeared, lordship. And as per the involvement, FIR, lordship, there are clash between two worker groups, lordship, labor groups. We are not there. We are the ownership of that GM Coke Industries. We are residing at lordship Tinsukia.
They have appeared.
Both are partner.
And one, Gamital has also appeared.
As per my information, all appeared, but statement, whom statement they have, I will have taken.
So if statement has not been paid, I will appear again, Lordship, for recording my statement. My bail may be absolute with a condition.
Heard Mr. P.P. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that petitioners, plural, that the petitioners were granted interim anticipatory bail by this court on 26/2025, and in pursuant to the directions of this court, they have appeared before the investigating officer. Stop. And have cooperated in the investigation. Stop. Learned, on the other hand, learned additional public prosecutor has produced the case diary of Sonapur PS case number 95/2025 and has submitted that though the petitioner number 2 and 3, though the statement of petitioner number 2 and 3 have been recorded by the investigating officer, the statement of petitioner number 1 is not there in the case diary. He also submits that there are materials to indicate that on the instigation of the present petitioners, no. Against them, there is no material. That there is no incriminating materials against the present petitioners in the case diary. Stop. Considering the submissions made by learned counsel for both learned additional public prosecutor, the interim bail granted to the petitioners by order dated 26/2025 is hereby made absolute. Send back the case diary. This bail application is accordingly disposed of.
44. Second time, limited by the clarity, by the your lordship. Paragraph 8, paragraph 12 is my new grounds. But several cases are pending between all the political parties. About 5 cases are pending. So earlier, some cases are mentioned, my lord, and some cases not mentioned. We have got now in the before the lordship, my lord. Can you see, my lord? Your lordship is at page 52 item is there, but can you see page 8, paragraph 12 is the new ground.
Yes. Who are you? What is?
You are actually named in the fire, madam. But
How many petitioners are there?
yes, no, here, my lord, actually petitioners are total 7. Idea, 2 petitioners filed comprising 7 persons. Your lordship order is page 52. First order, that 3 persons, then another case, 15/5/25. Your lordship order is page 52. Series of cases pending before the parties, madam. My only question, madam, the specific allegation, that is main question, whether I do not up to the series, your lordship was pleased to call for, madam. Anything is there, my lord, I leave to on that, my lord, only that here, madam.
Up to date case. Shalom is before this.
Yes.
Shalom, yes. Then Sanwar is there.
The fight between 2 groups, 1 of Shad group, 1 Mathin groups. So the present petitioners actually they said that we belong to that group.
No, out of these 7 petitioners,
Yes.
only 3 have approached.
Again, another order is there.
Another
Separate.
order. Which order?
Page 55. Same day. 4 persons, my lord, page 55.
Saiful, Naushad is there. Saiful. Abdul Hamid.
The seventh one,
So all have,
all have appeared.
what was the ground for rejection?
And the rejection, my lord, your lordship will find, you say that what a city in materials against all of them. That is, your lordship's order is page 53, paragraph 7. On perusal of the case, there it appears that though one of the person from the group of the petitioner has died, however, it appears that the allegations against the petitioners regarding retaliatory action by them in respect to death of Sujawali, it also appears from the case diary that the victim has sustained grievous injuries on his person apart from certain multiple injuries, materials against all the petitioners. So this is the now, madam, that order is may. Maybe some improvement might have as per because
Yes, so the incident occurred, this incident occurred because there are earlier there was some multiple was there because of the
right.
Died.
Right.
Because of that incident, when he died, then that group came again to the house of the informant and like the house, several persons were with all of the lucky the person along with him. And there are materials for that otherwise
All had whether a specific role, my I am only on that for the one person, whether total 22% name in that.
Son-in-law, daughter and one son. They were in the house, they took the name of 6-7 and another took 1.
My one question, my lord, can is page 26, the FIR filed long back. Ultimately, my lord, occurrence we are not denying, my lord. Altercation between the parties long back, it is going on the page 26, FIR 6/9/24. Wife of Nosod filed the case, my lord. Page 26. Again, your lordship will find page 32. It is also for both the file prior to present case, my lord.
No, that's the person who
So another case was on the same day. So 3 cases are filed by us, by our party against them, my lord. So occurrence, my lord, only question, my lord, whether they are, my lord, custodial interrogation on that person by this time, my lord. That is the only thing you lost.
No, no.
All the persons. I am
No.
only all the persons, my lord.
No, but when once your bail was
That's
anticipative,
there, my lord, but
bail was rejected.
the paragraph
There
I
is-
have stated, paragraph
No.
12, page 8.
this present.
I know, my lord, my limitation, I know, my lord. Second time, my limit, I know, my lord. But only question, my lord, whether that paragraph 12, page 8. If you lost fine, my lord, along with the city, I have, then I lift your lordship, my lord.
Shahjul. Who was the injured?
Yes, one Sujabali died.
No, no,
Oh,
from the other side. When Sujabali died,
Yes,
you assaulted.
that is the allegation, my lord.
Then from
Sujabali
your
died.
assault, who suffered injuries? What is the name of the injured?
22% named in the FIR.
Who is Shahjul Haq,
Shahjul Haq is my lord,
your brother of the present?
brother of petition number 1.
How it is relevant?
Hajrat Ali was my lord, actually, the husband of the informant was the injured. Hajrat Ali. And against Hajrat Ali, all other cases are filed, madam. Now, what happened to Hajrat Ali? Well, 22%, my lord, attacked him and he is still quite okay, my lord. No, anyway, my 22 persons assaulted on a person and he's quite safe now.
No, but fresh grounds are not convincing. Fresh grounds for anticipatory bail.
No, fresh ground only that much with that paragraph 12 I have stated, my lord, about Suja, yeah, my lord. That I know my limitation in so far the second petition is concerned, my lord. But here, the medical document of Shajul Haq, that is brother of the my lord, page 8 paragraph.
No, how it is relevant?
The depend only my lord about the merit of the case, of course. Though your losses seen the 2 months back, my lord. Maybe I am saying that subsequently may get something,
No,
my
there
lord.
is no.
That I am only on that, my lord. Otherwise,
Learned-
those things, some of them were not brought before lordship earlier, my lord. That is the only case.
Okay, heard Mr. H.R.A. Chaudhary, learned counsel for the petitioner, learned senior counsel assisted by Mr. J.
Ahmed.
J.H. Ahmed, learned counsel for the petitioner. I'm not keeping you waiting. I'm dismissing this.
My lord, I know my limitation. I leave to your
I'll
lordship.
pass orders in chamber. Chamber
My
will
lord.
handle.
Obliged to your lordship.
Item 45. May I please your lordship? Lordship, CDU was called for.
Chamber কে কারণ more time नहीं लेगा. Yes, what is your submission?
My submission, my lord.
Also,
Please.
notice is served.
Notice served. 45. Notice served, my lord.
Not served.
45. I have the receipt. No, that's how the receipt was.
No, office, as per office note, notice is not served.
But I have received, my lord. We have already. Did.
No, whether it was served or not, you have any information.
Practically, it has been served or not, I don't have any information.
You have,
But
you
I
have-
have taken the step.
You have only taken steps.
Yeah.
So we have to verify. PP shall verify. Heard, Mr. What is your name?
My lord, I have a submission, my lord. This is totally false case. There is counter case.
No,
also.
that, therefore, you are alleging for falsity of the accusation. Therefore, the victim has to be heard. Heard, Mr. What is your name?
ATM Hussain.
ATM Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. The office note dated 28/7/2025 shows that the notice issued to the petitioner has not yet been served. The full stop. The additional public prosecutor, Mr. K.K. Parashar, is requested to take information from the officer in charge of jurisdictional police station regarding the fate of the notice issued to respondent number 1 and let this court know about the same on the next date fixed. Let this case be listed.
Early date will be given, my lord.
When? Mr. Parashar. You suggested it. Fifth,
August.
5th of August.
Obliged, my lord. 46.
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
25/7.
Stop. In view of the fact that the charge sheet has been submitted in this case, this bail application is disposed of with an observation that the petitioner may approach the trial court and may file regular bail before the said court, if so advised.
Meantime, Lordship, 15 days, I may be protected, I'll be appeal, Lordship.
What protection?
Interim protection, Lordship.
Against what?
Lordship, under the section is non-valuable, and if I will be appeared to the court below, Lordship. So on that basis,
You don't have,
this is just my
there is no apprehension now.
apprehension, Lordship. This
We
section-
don't have time to engage in conversation with you now.
Lordship. This is published.
Can copy not issued, but here, Lordship, on last occasion, NBW was issued against the petitioner, Lordship. So at least my prayer is that that NBW may be stayed, Lordship. Otherwise, if he is arrested, that matter will become infractor of Lordship. On 28 matter was there, NBW was issued.
Which case?
In the present case, Lordship.
No. What is the offense?
Offense, Lordship, that 109, 103 was subsequently added. It was there, charge sheet was submitted. Other persons all are on bail, and similar situated person after charge sheet also approached this court. He was also granted bail, Lordship, that's page 47. And I also paid bail on the ground of parity. Then and on the ground that the matter is at committal stage, so I may be I will be taken to the if I.
But whether that power can, you have to come before this court by filing a appropriate application under 482 or 528.
Yes, this application was filed, okay? That this application is pending 482.
Not 482, 528. 482, you don't have a right to invoke the powers under 528. Though this court has that.
No, here my prayer was that when Lordship that someone was available warrant was issued, at that stage I came before your Lordship. And Lordship has after perusing the record.
Available warrant.
Yes, available warrant.
And then now
Now that on last occasion on 28 I failed to appear, and therefore warrant of arrest is issued.
But
Lordship wanted to see whether I am on same footing with page number 47 or not. Because of that purpose, Lordship has called for the case record.
what happened to 47?
On page 47, Lordship will find that Zakir Khan, I am on similar footing. He was granted bail by coordinate bench after filing of charge sheet on the ground that the case is pending at committal stage. So if he, because of that apprehension, he was protected, Lordship.
The offense is under what provision?
103 and 109 is there. Sessions tribal case. Charge sheet.
No, but this power I cannot exercise under 482. Now regarding stay of, you are seeking relief of stay of execution of the non-bailable warrant. For that, you have to file appropriate application.
Sir, issuance of warrant of arrest, that bail application is maintainable.
No, that is maintainable. We will consider this after.
Because in the order your Lordship will find that it is written that he was avoiding.
No, scan copy, what was called for?
Here, one and Lordship will say that it appears that accused so-and-so is absconding to avoid process of court, but I am before this court. I am not avoiding the process of court. In last two paragraph, Lordship will find in the order.
But I was reporting.
Because there was a direction to send back the TCR, Lordship, that was not sent.
I was reporting that all attempts were made, but he was not found. And my lord, now since it's been charged and warrant of arrest is approved, only he has to come with approved application, as you know.
Somebody died in this case.
Child was brutally killed with wooden.
No.
Yes, madam. I have got the informant.
So what is the accusation against you? What are the materials against you?
In the
That
FIR,
we have to peruse from the, you may not be on the same footing.
My submission was that I am on same footing with.
But to verify that, we have to peruse the case diary.
Till then, lordship, that execution of warrant that may be stayed.
No,
Because
that for seeking that relief, you have to,
present application is pending before your lordship already. So in that case, lordship may observe, because my interim prayer is.
okay, yes. Till we peruse the case diary.
Till provision of record that way.
Strong objection against this.
Because interim prayer is also.
No, if there are,
According to law, that you are not be doing in all the cases.
no, he has approached this court only because the committal court cannot grant him bail. Therefore, he has approached. Now,
Now,
co-accused have been granted bail by coordinate bench. Our only concern was to verify whether accusation against him are graver than those who have been granted bail or not, or whether he stand on same footing. He might have more role. If his role is more, he may not get bail in this case. But if it is not there, he will be granted bail. But in the meanwhile, non-bailable warrant have been issued.
Interim prayer is there at
because
case now.
pending petition, they are avoiding.
But next date is in the, no, next date is fixed on 28/8. What is the next date?
28.
28/8. So before next date, we will fix a date
Yes.
before.
No,
No,
I am not seeking.
before next date. Okay. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor, as well as Mr. S. C. Bishwas, learned counsel for the informant. On perusal of the office note dated 29/7/2025, the scan, it appears that the scanned copy of the trial court records as well as the scanned copy of the case diary of the connected case have not yet been received by the registry. Stop. Learned counsel for the petitioner has approached this court mainly on the ground, has approached this court seeking anticipatory bail mainly on the ground that the committal court may not allow the petitioner to go on bail even if he appears before the said court due to the embargo of section 480 within bracket 1 within bracket Roman 1 of BNSS. He also submits that in the meanwhile, co-accused have been granted bail by one of the co-accused.
Others also granted bail during investigation, one accused after charge sheet.
One of the co-accused have been granted anticipatory bail by a coordinate bench of this court after filing of the charge sheet, and he submits that the present petitioner stands on yes. No, wait for the order. Has Kalika stands on the same footing as that of the petitioner who has been granted bail by the coordinate bench. However, learned counsel for the petitioner submits that in the meanwhile, the trial court has issued non-bailable warrant of arrest against him. He submits that some interim protection may be granted before arrival of the scanned copy of the records as a pending non-bailable warrant is there against him. And if same is executed, this anticipatory bail application would become infructuous. On the other hand, learned counsel for the informant has opposed the grant of any interim protection on the ground that the case is pending. The case is pending before the committal court only due to absence of the present petitioner, and same could not yet been committed to the Court of Sessions. It appears from the copy of order dated 28/7/2025, passed in PRC case number 417/2024, produced by learned counsel for the petitioner, that next date of the said case is fixed on 28/8/2025. Stop. Since this court stop. This court is also of the this court is convinced with the submissions made by learned counsel for the petitioner that if interim protection is not given to the petitioner at this stage, and if the non-bailable warrant of arrest is executed against him, this anticipatory bail application would become infructuous, as this court is in session of the present anticipatory bail application, and scan copy has been called for. Therefore, it is of the view that before consideration of the present anticipatory bail application by this court, the non-bailable warrant of the arrest issued against the petitioner by the committal court should not be executed. Hence, till next date, the execution of non-bailable warrant of arrest issued against the petitioner is stayed. Release this matter when
That PRC case number will be mentioned also, that PRC 417/24.
yes, I have mentioned it, 417. Release this matter 20 August. Registry to issue reminder for the scan copy of the trial court records and case diary, and shall ensure that shame should reach this court before the next date fixed. List accordingly.
Obliged.
You could find out. We are disposing of as per your instruction.
My lord, charge sheet number is my lord, so my lord, I could collect lordship. CS number, photographer PS number 50. My lord, dated 36/2025 lord.
So
Now, yesterday, my lord, I got this, my lord, but for confirmation.
no, we believe you. We don't need confirmation. We believe your submission.
His bail petition may be considered, my lord, already 54 days, my lord. My lord, dowry debt, sorry.
No, you
22, my lord.
appear before the trial court.
109, my lord, is not my lord, charge sheet at lordship. So,
No,
my
you
lord,
appear before the trial court. No,
at this stage, your lordship also may consider lordship.
Heard Mr. M.H. Ahmed, learned counsel for the petitioner. Also heard Mr. P.A. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that he has been informed that charge sheet has been laid in this case bearing charge sheet number
50
50 dated
36 2025.
36/2025. Stop considering the submissions made by learned counsel for the petitioner. This bail application is disposed of with an observation that the petitioner may approach the trial court and may file regular bail, may file an application for regular bail before the said court, if so advised.
My lord, may be considered, Lord, directed to be considered. Positive way, lordship, I hope, but it is hopeful, Lord.
It will all, I don't put such,
My lord, for consideration, lordship,
no such instruction would be necessary if there is an apprehension that court would not consider. But every court is
Definitely
there,
will consider,
every
Lord.
court is there to consider, and
lordship's
Yeah,
direction is, my lord, given with
no.
any lord. All right.
Yes. 22 is last item. Yes. Item number 22.
Matter is fixed for admission, your lordship, and this, there is an order of stay passed on the last occasion, that is on 3/2/23,
Stays there.
stays there. That may kindly be extended.
We'll admit it.
As your lordship.
We'll admit it and
They don't have objection.
no, what is your prayer? What is the matter in this case?
This case, it was pending in the JJB board, and there the witnesses are not examined, and the matter was fixed for argument without examining the witnesses.
Okay.
To that effect, we have come before your lordship to set aside the said order. Otherwise, it will be prejudice to the petitioner without examining the witnesses if the matter will proceed for argument. That is the issue, and that is why we have taken the stay interim order to stay the further proceeding, and that has to be vacated.
Case is pending before JJB. You are CBI.
For the CBI lordship.
Why CBI is
The CBI itself.
Okay.
There was a complaint by.
Now, what is your grievance?
Witnesses has to be examined, which was closed.
You failed to produce the witnesses.
That, to that effect, I am not in a position to say right now, because the file is not with me as of now. But the concern is that we are not allowed to examine the witnesses, or witnesses are closed, that I will have.
Whether we will require the scan copy of the records. Where is the impugn order? Impugn order. You thought it would be the last item.
Exactly not, because it has been handed over to me recently. So the file is not with me.
Okay, then we'll adjourn it for some time.
But the factual, whatever I have gone through the record, it has come to my knowledge that the impugn order is 15/7/22 and 21/7/22 passed by the learned JJB. That has to be set aside because our witnesses are not examined and the matter proceeded for argument. So without examining.
You failed to examine, produce the witness since 2013.
And I am not exactly.
But unless that is verified, case may not be in your favor. If since 2023 you are not been able to, apparently you don't have a case. If the order in its face value, it is to be believed. If you don't have a counter to it. No, but you know the facts.
Today I have gone through the record itself to collect the order, to know the date of the order itself. So
Wait, how much
put
time
this
will you require?
exactly. It may happen, I need to have the certified copies of the record,
How much time you require?
2 weeks or 3 weeks minimum. Because I have to obtain the certified copies. We don't have bylaws.
Okay. So you are also praying for adjournment. Heard Miss, what is your name? Heard Miss M. Kumari, learned counsel for the petitioner, as well as Miss U. Sharma appearing for Mr. B. M. Chaudhary, learned counsel for the respondent. A joint prayer has been made at bar, praying for adjournment of this case on different grounds. Stop. The prayer is allowed. Let this case be listed after 2 weeks on a date to be fixed by registry.
Regarding item number 7, I adjourned the matter. It was in motion column and then fixed for tomorrow. Can be on Friday, my lord. My senior is not well, man.
Then take next Friday.
No, my lord, this Friday. It will be too long.
Your senior is not well. Why are you straining him?
He told me to fix on tomorrow, my lord, but he's not well, man. So can it be on 1st of August, man?
Let it be on Monday. Okay, 1st of August. Item number 7, reschedule koribo 1st of August.
Keep your place, man.